Welcome back to the Medigap Show. I'm Holly Cohen, your host, licensed agent, and founder of MedigapCares.org. Here with another episode of the Medigap Show, your trusted resource to help you cut through all that noise in the ever-changing landscape of Medicare in 2023. Today we're diving deep into a hot topic that's been making headlines. We'll be discussing a lawsuit just filed over the Medicare drug price negotiation program. Now let's dig into the details of that article. It argues that the negotiation process designed by Democrats last August is nothing more than a quote-unquote sham, claiming that the federal government is dictating prices and violating constitutional rights. It's the constitutionality of the Inflation Reduction Act, raising concerns about the government's power to force drug makers to sell their property without fair compensation. Merck believes that the penalties for non-participation in negotiations could be financially devastating to them. The lawsuit does raise some crucial questions about intellectual property rights and the limits of government intervention in the healthcare market. The outcome of this case could have far-reaching implications for both drug makers and Medicare beneficiaries. Stay tuned as we read into the article and explore the arguments presented by Merck and the potential impact this lawsuit may have on future of drug pricing negotiations. Remember, knowledge is power. And here on the Medigap Show, we're dedicated to equipping you with the information to make the best decision about your Medicare needs. So if you're ready to dive into the complexities of the Medicare world and stay ahead of the game, don't forget to subscribe and hit that notification bell so that you're notified every time a new episode comes out. And don't hesitate to reach out to us at MedigapCares.org for your personalized phone appointment.
So here we go on today's article. This was posted to STAT, and the title is Tantamount to Extortion, Merck Sues U.S. Government Over Medicare Negotiation Program by Rachel Kors and Ed Silverman. And this article was posted on June 6, 2023. Merck on Tuesday sued to stop the federal government from implementing a new Medicare drug price negotiation program. Merck called the negotiation process that Democrats designed in a law last August a sham, arguing that the federal government dictates prices. The company argues in the lawsuit that the Inflation Reduction Act is unconstitutional for two reasons. The first is because the law allows the government to force drug makers to sell their property without just compensation, which the company argues violates the Fifth Amendment. Merck says the government would effectively be taking its drugs because of the sheer size of penalties the company could incur if it decides not to participate in negotiations. It estimates that the fines for its first day of resistance for one drug alone could amount to tens of millions of dollars. The drugs themselves are property that the government would be taking, Merck contends. They are also patented, which makes them doubly protected. However, the law does not allow generic and biosimilar manufacturers to begin making a drug, which would be the case if a patent were actually invalidated. The argument related to intellectual property is untested. The Supreme Court has avoided directly ruling on whether a patent like the one drug makers hold qualifies as a protected private property, and it would be a big deal if the justices actually decided the issue. Applying the takings clause to patents would be like the shot heard around the world, said Robin Feldman, a law professor at the University of California, Hastings, shortly after the law passed. Feldman said on Tuesday that she views the case as a likely candidate to head to the Supreme Court. But even if the government isn't taking a patent itself, it could potentially cause it to decrease in value significantly, which could be considered the government taking a company's property. The Congressional Research Service analyst wrote in a 2019 report on an earlier draft of the drug price negotiation law, a government program demanding discounts from drug makers isn't unprecedented, as the Department of Veteran Affairs bargains with drug makers and pays much lower drug prices than Medicare. The second reason the law is unconstitutional, according to Merck, centers on the government's pitch that the program is essentially a voluntary agreement between Medicare and a drug company to a fair price. That idea, Merck argues, violates the compelled speech doctrine of the First Amendment by agreeing that a negotiated price with the government is fair. A company would implicitly be saying that the market prices charged to every other population are unfair, Merck writes. This is not negotiation. It is tantamount to extortion, the company writes. The only way for companies to avoid the negotiation program is by withdrawing all of its medicines from the Medicare and Medicaid programs. No rational manufacturer could simply withdraw from half of the U.S. prescription drug market, leaving tens of millions of patients without their medicines, Merck writes. Merck asked for the court to stop the federal government from forcing the company to sign a contract to agree to prices through the Medicare negotiation program. The lawsuit is expected to be filed in the U.S. District Court for the District of Columbia. We are confident we will succeed in the courts. There is nothing in the Constitution that prevents Medicare from negotiating lower drug prices, said White House Press Secretary Karine Jean-Pierre. Medicare is supposed to choose the first drugs to be selected for the program by September 1st. Merck's diabetes drug, Januvia, is a potential candidate for the negotiation program's first cycle, and its diabetes treatment, Janumet, and cancer blockbuster, Keytruda, could be eligible in the near future. Rick Weisenstein, an analyst with TD Cowen, told investors that he believes the Merck lawsuit is only the beginning of a barrage of litigation by drug makers, that it's likely the process could delay the start date for the negotiation timeline. However, Eric Gordon, a clinical professor at the University of Michigan's Business School and a former law professor, said that there are better odds that Elizabeth Holmes wins MedTech Innovator of the Year than Merck wins its lawsuit.
So the lawsuit filed by Merck against the U.S. government over the Medicare drug price negotiation program has ignited a heated debate in the healthcare industry. Merck claims that the negotiation process is unconstitutional and akin to extortion, arguing that the government's involvement in dictating prices and potential penalties infringes upon their rights. The case brings to the forefront the complex issues surrounding intellectual property rights and the role of government in regulating drug prices. It remains to be seen how the courts will interpret the constitutional implications of this program and whether it will set a precedent for future negotiations and industry practices. As we continue to navigate the evolving landscape of Medicare, the outcome of this lawsuit could have far-reaching consequences. It's our mission to empower you with the knowledge and resources that you need to make informed decisions about your Medicare coverage. We're here to guide you through the complexities of the Medicare world, ensuring you have the information you need to make the choices that align with your healthcare needs and preferences. Reach out to us at medigapcares.org. Schedule a personalized phone appointment with me or a member of my team for your Medicare coverage and ensure you have peace of mind. Thank you for joining me today on the Medigap Show. Stay tuned for more insightful discussions and updates on Medicare-related topics. Until next time, take care and be well.